Good morning, good afternoon, and good evening. Welcome everyone to this section of Law is Science. My name is Dongjun Chen, and I'm a JSD candidate at the University of Illinois College of Law. I will be your moderator for today's session. Before we turn to our speaker, Professor Mazzone, let me briefly introduce the Law of Science project. Law of Science is an academic initiative originally founded by a group of JSD candidates from across the United States who share a strong belief in the value of applying interdisciplinary methodologies to legal studies. We regularly host lectures featuring scholars with a wide range of methodological approaches. If you want to learn more about the Law of Science project, please visit our website and join our email list. We would love to stay connected with you. Meanwhile, I would like to briefly introduce our team. Simon Sang, co-founder of this initiative and assistant professor at the National Yangming Jiaotong University School of Law in Taiwan. Chucky Randham, the chief editor of our blog, The Legal Method Lab. Vanessa Venueva, our senior fellow. Marilyn Haidt, SJD candidate at the University of Virginia School of Law, Stuti Shah, JSD candidate at Columbia Law School, and me, JSD candidate at the University of Illinois College of Law. We also have representatives from diverse law schools in the US, such as Indiana University, UC Berkeley, University of Pennsylvania, and University of Wisconsin. If you are interested in getting involved, we are always looking for new law and science representatives. We also host a blog on legal methodology, the Legal Method Lab, and we are always on the lookout for new editors. Now let's turn to today's esteemed speaker, Professor Jason Mazzone. Professor Mazzone is the Albert E. Jennifer Jr. Professor of Law at the University of Illinois at Urbana-Champaign, and Director of the Illinois Program in Constitutional Theory, History, and Law. Professor Mazzone's primary focus is constitutional law and history, with particular attention to how constitutional structure shapes individual rights. In the US context, he is a widely recognized leading scholar of the US Constitution, and his work has appeared in thousands of prominent legal journals. His scholarship has been cited by numerous courts, including the US Supreme Court. He also regularly advises litigants on a pro bono basis in cases before the Supreme Court and other courts. In the international arena, Professor Mazzone has lectured globally on comparative constitutional law and has advised emerging democracies in the process of drafting and implementing their constitutions. He also works extensively in the field of intellectual property law. He coined the influential term copy fraud and is the author of the book Copy Fraud and Other Abuses of Intellectual Property Law, published by Stanford University Press in 2011. His work has contributed to legal reforms, court rulings, and policy changes around the world. Professor Mazzone holds degrees from Harvard, Stanford, and Yale. He's currently working on two new books. One, a global study of the future of constitutional rights. The other, an exploration of how the US Constitution functions as both unifying and dividing forces in American society. Today, Professor Mazzone will be speaking on uses and misuses of history in constitutional interpretation. Before we begin, just a quick note, we will have a Q&A session at the end, and we truly welcome your questions and insights. Professor Mazzone, the floor is yours. Thank you.
Well, thank you so much. And I have a few slides, so I'm just going to load those up and get started. It's great to be with you, and I appreciate your attending. I am going to talk about uses and misuses of history in constitutional interpretation. So we're really talking about interpreting provisions of a constitution, obviously in the context of courts adjudicating constitutional disputes, but not only courts. So uses of history by lawyers in arguing to courts, and uses beyond courts as well. So this might include other governmental actors besides courts that are interested in constitutional meaning, perhaps because they want to adopt a law or implement a policy, and they need to understand what the Constitution permits, what it prohibits, or perhaps they want to understand allocations of power, who is responsible for what. And then also outside of government, other people concerned with constitutional meaning might be lawyers advising a client, and then more broadly, just members of the public interested in what the Constitution means and requires. So there are lots of contexts in which history might be used in interpreting a constitution. I will focus a lot on courts, but please don't forget these other contexts as well. I should also say at the outset that I'm going to talk about the US Constitution, but the question of using history in interpreting a constitution is not limited, of course, to the United States. Oh, that's me. I might point out that I have a book that I edited recently called "Uses of History in Constitutional Adjudication." It's part of a series that I edit on comparative constitutional history. It has chapters about various countries and comparative analyses of when, how, why history gets used or not. So I don't mean to suggest that this is only limited to the U.S. Now, if we talk about adjudication in courts, we're necessarily dealing with history. In a very general sense, all constitutional adjudication is historical. If all law is historical in a sense, courts resolving constitutional disputes necessarily are examining events that occurred in the past, laws that were adopted in the past, in light of the provisions of a constitution that itself was adopted in the past. So there is necessarily a sort of historical element to all of this, however you approach the issues. But to say that is not especially interesting, doesn't get you to the real points of variation and challenge and contention. These things arise when we recognize that constitutional interpretation, whether in resolving a concrete case or for another reason, invites consideration of other historical materials and sources that might shed light on the meaning and application of a constitution's particular provision. So that's really what I'm going to focus on in this session. And there's a lot of debate, as you probably know, about the relevance and reliability and accessibility of historical sources for construing a constitution and deciding constitutional cases, and debate about the very justification for that enterprise. There are lots of different ways, I think, of entering this discussion, and I think I'd like to talk first about some different modes in which history gets used, again, particularly in interpreting the US Constitution, and then turn to some of the challenges and problems, and of course save some time for your thoughts and questions. Now, the most obvious starting point when we're talking about the US Constitution and history is this, originalism. So let me say a bit about that very briefly. Originalism is a family of interpretive approaches. So there are different versions of originalism, but they have two things in common. First, an idea of fixation. So the meaning of the text is fixed. It does not change over time. And second, the other thing that these variations of originalism have in common, a notion of constraint. So constraint principle, the original meaning of the text, again, which does not change, is binding. Judges and others are constrained by it. You don't get to do something else. Now, originalism, I should say, is not a new idea. Chief Justice John Marshall was an originalist. He didn't use the term. He was an originalist. McCulloch versus Maryland, 1819 case that you might have encountered. It's a case that holds that Congress has power to create a national bank. States may not tax the bank. It's a thoroughly originalist opinion. Joseph Story was an originalist. Hugo Black was an originalist. So, there's a kind of long history to originalism itself. Today, originalism gets associated with conservative justices and conservative scholars, but it's wrong to think of originalism as linked necessarily with political conservatism. There are political liberals who identify as originalists, and originalism doesn't necessarily lead to outcomes that conservatives favor as a policy matter, if that's sort of what you care about. Now, I said there are different versions of originalism. I can't talk about all of them today, but the version that is dominant today in the United States is this public meaning originalism. And the key idea of this, is very briefly, is that the words of the Constitution should be understood to mean what they meant to an ordinary adult citizen at the time that the Constitution, or an amendment, if you're talking about that, was adopted. This is different from how originalism often gets reported. It's often reported as the Constitution should be understood in the ways it was intended by its framers. There was a period in the 1970s and 1980s in which framer intent was the focus of those who identified as originalists, but it's very much fallen out of favor, mostly because of a series of criticisms, including that the framers of the Constitution themselves didn't embrace the theory of intent as a valid method of constitutional interpretation. Figuring out the intent of a collective body is very difficult, maybe impossible. Participants in a drafting or ratifying process may have had different intentions from each other, may have had secret intentions that they never revealed. And even the idea of intent is very problematic because depending on the level of generality, it can mean very different things, right? It could be an abstract idea versus a very, very specific outcome that you quote unquote intend. And then, of course, as to the evidence, you have to kind of dig around to see what people said in debates or other statements or other writings to see what they intended, and sometimes you're guessing about that. Many of the relevant participants might never have said anything at all about what they intended. So for a variety of reasons, this sort of a brief period of great interest in original intent, I think it's not that it's completely disappeared, but really doesn't characterize originalism as it is predominant today. Public meaning originalism is not concerned with intent. It's concerned, as I said, with the meaning of the text to an ordinary adult at the time that the text was adopted. And so lots of historical sources become relevant to discerning that ordinary meaning. You might be interested in what was said at, say, a constitutional convention or the ratifying convention, might be interested in what was written about in those contexts. But those sources are not necessarily of any special significance, right? Ordinary meaning invites looking to dictionaries, newspapers, books, and other kinds of materials available to ordinary people to make sense of words, text, that were ratified as part of the Constitution. Okay, a little bit more on this. An important aspect of public meaning originalism is this distinction, a distinction between constitutional interpretation and constitutional construction. I want to say just a little bit about that because it does bear on our discussion today. Interpretation is what I've been talking about, is the activity of discerning the linguistic meaning of text. Construction is a different undertaking. It's the activity of determining the legal effect of the text, how that text is going to be applied. These are different activities. And importantly, discerning original public meaning, the way that I've described it, is an act of interpretation. A lot of other work using different kinds of tools might be done in the construction zone, right? So in particular, when you're engaged in interpretation, original public meaning might run out. That is to say, the original public meaning of a text might be vague or underdetermined, right? You've searched high and low, but you're still left with the conclusion that it's vague, it's underdetermined. And if that's the case, then you need construction to figure out the legal effect of the textual provision. And that is going to involve tools other than original public meaning. These might be historical tools, but they might be other kinds of tools. I emphasize this because originalism is often criticized as unrealistic, as naive, right? Critics say text can mean different things. You can't resolve modern disputes based on historical meaning. But these sorts of criticisms, I think, reflect a misunderstanding. Originalists fully understand that constitutional text might be underdetermined, might be vague. And they have built into their account this interpretation, construction, distinction that reflects that recognition. Now, of course, there can be disagreement about which provisions of the Constitution are vague or otherwise underdetermined, right? That can't be resolved through sort of this historical inquiry. There's also disagreement about which kinds of tools you use when you are working in the construction zone and public meaning based on historical sources has run out. But I do want to emphasize this difference. And I want to say one more thing about this, which is that because of this distinction between interpretation and construction, there might actually be less of a gap between public meaning originalism and what's often thought of as its chief rival, a sort of living constitutionalist approach, less of a gap than is often thought. But these are not necessarily rivals because we might understand living constitutionalism to be a valid and useful method of construction, right? When you're in this second category, so maybe they're friends after all. Okay, so these are the basic ideas of public meaning originalism. Obviously, very historically focused approach. The Supreme Court today is very interested in this. You will see opinions which a majority of the court says this is the method we use in constitutional cases. I should also say at the state court level. Many state courts adopt this as a matter of interpreting state constitutions. If you want an example, I suspect you've come across them. You probably come across this one. One example of this in action is the 2008 decision, District of Columbia versus Heller, in which the court goes about determining the original public meaning of this provision, the Second Amendment of the Constitution. The question, as you may recall, is whether the Second Amendment protects an individual right to possess on the facts of the case, a handgun at home for purposes of self-defense. The government argues, no, it's not an individual right. It's all limited to the context of militia service. Justice Scalia writes for the court. He rejects the government's argument and says, no, this is a provision of the Constitution that does confer an individual right to possess a firearm for purposes of self-defense. And he gets there through a method of original public meaning. Right? It says the understanding of the second clause of this provision, the right of the people to keep and bear arms, would have been understood by the ordinary person on the street in 1791 as including a right to possess firearms for purposes of self-defense. Right? And you can go look at the details of his reasoning to see whether you are persuaded by his understanding of that textual provision. But that is what he's doing in DC versus Heller. Okay, so this might lead you to ask, well, why use this approach? What's the sort of benefit of this sort of public meaning, historically grounded approach to constitutional interpretation, the approach that is, as I said, quite prevalent at the U.S. Supreme Court? There are different kinds of justifications that have been offered for public meaning originalism. The two big ones, and they are related in certain ways, is that public meaning originalism is said to be the method that is most consistent with popular sovereignty. So it's a kind of democratic popular sovereignty justification. The idea is that we, the people, ratified the Constitution. And so the understanding of we, the people, at the time of ratification is what counts until we, the people, change the Constitution. How do we change it? By adopting new text. So that's one big justification. And then relatedly, public meaning originalism is said to be the method that is most likely to constrain judges, to make sure they are adhering to what we, the people, did. They're not pursuing, implementing their own preferences because that's not their job in our constitutional system. Originalists don't claim that their method is perfect to protect and promote popular sovereignty, to constrain judges, but they do claim that it is better than any other method. So therefore, it's the one that we should prefer. Okay, so that's enough about public meaning of originalism for the moment. I want to shift gears a little bit and talk about another mode of use of history and constitutional adjudication, and that's this idea of history and tradition. It relates to originalism, but it isn't public meaning originalism of the kind I've just described. The US Supreme Court, again, has become very interested in history and tradition as central to determining the meaning of the US Constitution, and particularly the existence and scope of federal constitutional rights. And I want to illustrate this with two recent cases. There's lots of other cases as well. The two cases, they both involve claims of rights. You may have heard of them. One case is New York State Rifle and Pistol Association versus Bruin, which is a Second Amendment case. The other case is Dobbs versus Jackson Women's Health Organization, which is the abortion case that overturns Roe versus Wade and Planned Parenthood versus Casey. So Bruin, this is the case if you want to look it up. Bruin involved a New York statute that said if you want to carry a concealed firearm outside the home, you have to have a reason. You have to show a proper cause, meaning you have to prove to the state, to the government, to the licensing official that you have a special need for self-protection, different from the rest of the population. The Supreme Court held that this requirement violates the Second Amendment. Justice Thomas wrote for the majority. It's a 6-3 decision. The decision is historically oriented, historically grounded, but it's not especially originalist. There's a little bit of originalism, a little bit of public meaning originalism in the opinion. The couple of paragraphs that say that the Second Amendment right, personal right to possess a firearm for self-defense extends beyond the home. But New York did not actually dispute that proposition. It really just wanted to defend its licensing scheme as a permissible regulation of the right. And Thomas is interested in setting out a historically grounded methodology. It's really for lower courts in order to assess Second Amendment claims brought, really to challenge other kinds of laws as well. So he's not just interested in this particular case. And that's because since the early case I mentioned, DC versus Heller, and then McDonald versus Chicago, which holds that the Second Amendment applies to the states, the lower courts deciding Second Amendment cases had adopted a balancing test. They essentially adopted a sort of means and scrutiny case, balancing the government's interest in regulating the right to possess a firearm against the right. And in most of those cases, the government was able to prevail in its regulation. Thomas said in Bruin, this isn't the right approach. Courts should not be doing this kind of balancing. It's all too deferential to the government. It doesn't sufficiently respect the Second Amendment right. And so Thomas said in Bruin, in order for the government to regulate with respect to the possession of firearms protected by the Second Amendment, the government must affirmatively prove that its firearm regulation is part of historical tradition. So here's sort of the key language. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it, meaning the regulation, is consistent with the nation's tradition of firearm regulation, or if not, the regulation is invalid. So the government has to prove that the regulation that is defending has a historical pedigree. You have to be able to point to analogous laws regulating firearms at the time that the Second Amendment was ratified. As for Bruin, Thomas says New York hasn't demonstrated that there's a tradition that would support its special need licensing law. There were various historical regulations of bearing arms in public, but nothing close to the sort of discretionary licensing scheme that New York had adopted. So the government failed to make the showing, an analogy, and the law was invalid. The court modified the test a little bit later in a case called United States versus Rahimi, in which it actually upheld a law, a federal statute prohibiting individuals subject to a domestic violence restraining order from possessing a firearm. It's an 8-1 decision over a dissent by Justice Thomas. The court there says, when you look into tradition, in accordance with Bruin, you don't have to identify a perfect historical match, just a similar tradition of regulation. Or you don't need a twin, you just need a cousin, right, in the language of the case. And in Rahimi, there was a long tradition at the time of the Second Amendment of regulating to prevent individuals who threatened harm to others from misusing firearms. Of course, not domestic violence specifically, but in other sorts of contexts. And that was enough of a historical pedigree to sustain what the federal government was doing. Again, over a dissent by Justice Thomas, who thought that there was no sufficient match. Okay, so that's one example of history and tradition. Another is this case, which you probably also have heard about, Dobbs. Dobbs overturns Roe versus Wade, overturns Casey, which had both recognized a right under the due process clause of the due process clauses of the Constitution, the 14th Amendment and the Fifth Amendment, to terminate a pregnancy, not an absolute right. Government could regulate, and in later stages could prohibit abortion, so long as there are certain exceptions, but a right nonetheless. Dobbs holds that the Constitution does not protect a right to abortion. It's also ends up being a 6-3 decision that Chief Justice Roberts would have simply upheld the statute in the issue in the case. But Justice Alito, writing for himself and for other colleagues, just rejects the idea that there is any constitutional right to terminate a pregnancy. And this case, too, is historical. But as with Bruin, it's not originalist. It's not a decision about the original meaning of constitutional text. It's a different kind of historical analysis. The analysis is based on a line of doctrine that says that the due process clause of the 14th Amendment protects some rights that are not mentioned specifically in the Constitution, but that list of rights is limited to rights that are deeply rooted in our history and tradition and essential to our nation's scheme of ordered liberty. So again, sort of historical approach. You're not actually interpreting the original meaning of the text. You're finding a protection for certain rights that have deep roots in history and tradition and are essential to liberty. A right to abortion, Dobbs says, doesn't count because there's no tradition, Alito found, of protecting such a right. Instead, Alito says, again, we're looking at the historical record, abortion was not protected under British or American common law by 1868 when the 14th Amendment was ratified. He points out that 3/4 of the states, 28 out of 37, had statutes making abortion a crime at any stage of pregnancy. And so the tradition is against the claim that there is a right. Again, this is about tradition, as in Bruin. So similar kind of approach, but I want to flag an important difference. In Bruin, the government had to show a tradition of regulating in order for its law to survive review under the Second Amendment. But in Dobbs, if you want the court to recognize an unenumerated right, you have to prove as the plaintiff that there's a long tradition of protecting the right to your claim. And the assumption is the right is not protected because it's not mentioned in the Constitution, right? Unless you can overcome that presumption and demonstrate that there is a deeply grounded tradition that supports recognition of the right. Okay, so far we've talked about originalism and history and tradition as two different modes in which history is relevant to constitutional interpretation. Let me flag just briefly some other ways, modes in which historical analysis can and has been relevant to interpreting a constitution, and then we can talk about some of the maybe issues and problems, and then turn to questions. Okay, so we just talked about tradition as informing the existence of and scope of constitutional rights. There's also a mode of analysis that looks to practice over time, but this involves practice after the Constitution was ratified, and it concerns not rights, but government powers. So the basic idea here is that if there's uncertainty about whether the government can do something, and we mean the federal government, which is of limited powers, or uncertainty about which branch of the federal government can do something, a long tradition of practice can resolve that issue. And there are two concepts here. They relate to each other, but they're distinct. One is this, called historical gloss. And this is the idea of practice can provide a gloss on historical text. This is especially common in the separation of powers context when you're deciding which branch of government gets to act. And there are sort of various sources for this idea, but the one that gets cited a lot is Justice Frankfurter, in the Youngstown case that you might be familiar with. So he says it's a still seizure case. He says a systematic, unbroken executive practice, long pursued to the knowledge of the Congress and never before questioned, engaging by presidents who have also sworn to uphold the Constitution, making, as it were, such exercise of power part of the structure of our government, may be treated as a gloss on executive power, right? The executive power that's vested in the president by Article 1. By Article 2 of the Constitution, right? So longstanding practice over time as to which Congress, right, which may have an interest in regulating, doesn't object, provides a gloss on the meaning of this provision, executive power, so that the practice is one that the president can continue to engage in. What's an example of this? The president ordering a military strike in the absence of a congressional declaration of war. Presidents do this all the time, and they say we can do it because it's always been done by presidents. Congress has never objected, and so the practice provides a gloss on the text, right? Power of the commander-in-chief to act preemptively, even in the absence of a declaration of war by the Congress. The other idea, and it's related, is that practice can liquidate constitutional meaning. This is more narrow. This is the idea. It goes back to some things that James Madison had said, that the early practices of the federal government, so soon after the Constitution was adopted, can liquidate, can fix the meaning of constitutional provisions that might be textually uncertain. So an example of that, the Constitution says nothing about the power of the president to remove executive officers, right? And it tells you that the president has power to appoint members of the executive branch, courts as well, of course, but members of the executive branch, but doesn't say anything about the power of the president to remove those people, something that's obviously in the news a lot today. But early presidents, this is a sort of liquidation idea, early presidents did assume a power to remove individuals that had been appointed to the executive branch. And so that early practice, according to liquidation, becomes a power that the president has, right? Liquidation means that this is something that the president can continue to do, not because of a long continuing tradition, but because of special significance attached to how the government acted in the early years of the Republic. Okay, a different use of history, sort of moving through some other modes now, might be focused on the origins of a constitution and its purposes. So there are lots of things you might think about in this context. The Constitution is a product of revolution. That fact might inform how you think about the meaning of the Constitution's provisions. So purposivism, which is a method of constitutional interpretation, very much in vogue in countries outside the United States, itself has a historical element because in order to understand purpose, you're almost certainly interested in the origins of the document. Let me mention one other thing. A nation's former constitutions might be relevant to interpreting the current constitution by, for example, demonstrating points of continuity, demonstrating changes, contrasts that have been that exist, and so on. I have a long article on this. I call the practice interconstitutionalism, sort of uses of prior constitutions when you're going about interpreting the provisions of your current constitution. Courts do this all the time. In the U.S. context, the U.S. Supreme Court has very often looked to the Articles of Confederation, the sort of predecessor constitution, in order to understand provisions of the U.S. Constitution, right? Because continuities, contrasts can provide evidence of constitutional meaning. there were lots of points of correction in the 1789 Constitution, given some of the defects in the Articles of Confederation. You see this at the state level as well, states that had multiple constitutions, and you see this happen also outside of the United States in nations that have had multiple constitutions. Courts very frequently look to predecessor versions of the nation's constitution. And then the last sort of historical mode I want to flag is this one, sort of a directive built into the Constitution itself. A Constitution might itself specifically refer you back to history and require attention to it. So a kind of constitutional directive, constitutional command. The US Constitution does this in places. I just want to flag one, this is the Seventh Amendment, which protects a right to trial by jury, but it's not a general right to trial by jury. Instead, the Seventh Amendment preserves a right to trial by jury in suits at common law, right? So you must look backwards to the common law to figure out the meaning of the Seventh Amendment. It's a command that is built into the Seventh Amendment to engage in a historical analysis. Okay, so these are all different modes of historical analysis. There, I think, questions that we might ask. There's potential difficulties in all of this. So let me say a little bit about those, and then we can turn to some. Oh, here's the confused person. Then we can turn to some questions and comments from you. One big question is who's responsible for researching the historical sources and giving a fair presentation of the historical record? Is it the responsibility of the parties in a case? That might seem to raise some risks. Each side is going to tell you the part of the historical story that's favorable to it. So can you really get a fair historical account by hearing from adversaries? And if lawyers are responsible, maybe law school should be teaching students how to do this stuff. I'm not sure that they really are. Is it the job of the courts to do the historical research? How are they going to do it? How well will they do it? Should we be appointing historians as, say, special masters in cases to do the research, relying on a friend of the court briefs from professional historians? What happens if different briefs say different things? Who's going to judge the reliability of the submissions? If you think about courts, there are some significant differences in terms of capacities. The US Supreme Court, which is the focus of a lot of media analysis, of course, and academic and public discussion, it's not a typical court. It decides a small number of cases. It has the benefit of extensive briefing by parties, amici briefs. It has the benefit of the opinion of the lower court. And it can take a lot of time when it wants in deciding on issues. It can decide, of course, what to decide in terms of cases to review and the questions to review and so on. Other courts generally have to decide the cases that appear before them. They have far fewer forms of help. They have many more cases. They're often deciding constitutional questions in the first instance. I think asking them to engage in sort of serious historical research presents some really significant challenges. Having said that, there's also big questions about what kind of history we want to be done in the context of adjudicating cases or interpreting a constitution more generally. Many historians don't like the sort of historical analysis they see in briefs or in court opinions, but a lot of criticism from professional historians of cases like Heller. But we might ask, is that really a sound objection? Is history that's being done in the context of interpreting a constitution the same kind of history that historians in history departments do? Are there relevant differences? Assuming you can get a full and fair historical account, I think there are other questions about resolving the legal questions presented, deciding the case. Do we imagine that a full and fair historical record will reduce indeterminacy in constitutional interpretation? Right? Is that a sort of verifiable claim? What happens when it does not? Because the record may be mixed or incomplete. What happens when the historical evidence seems relevant but doesn't perfectly address the issue being presented? How close does the history have to be? Who's going to decide those kinds of questions? We might also ask what kinds of presumptions and burdens are operating when we're making use of history in constitutional adjudication. Is it the government, as in Bruin, that needs history in order to support something it wants to do? Is it the person challenging what the government is doing, as in the context of unenumerated rights, who has to present the historical record and show that it's on her side? Allocations of burdens and presumptions does make a big difference in terms of the outcome of a case. Then we might think about what happens when an outcome that is supported by historical sources would be inconsistent with some precedent because the earlier court that decided the earlier case didn't use correctly the historical evidence. But what does it take for a historical inquiry to overcome, in other words, stare decisis? What happens when history is inconsistent with historical doctrine, with decisions from the past? How do we think about the development of a historical account today, given that a lot of issues have, of course, been decided in the past, and maybe not, based on a sort of historical method? I think there's also, as we sort of think about this general topic, big questions about how far we have come in accurately figuring out the historical record in a way that is helpful to interpreting, again, the US Constitution. We might ask the same question in other contexts. Are we at the beginning of that process, right? Are we just sort of getting started? Or are we far enough along that we can be confident about what we think the record shows, right? Where are we in terms of our knowledge and understanding of the sort of relevant historical sources? On that, I think it's noteworthy that there's a good amount of churn in the historical evidence and mappings of it onto constitutional provisions. There's a huge amount of scholarship being done these days. Scholars are regularly coming forward with new evidence and new angles and new interpretations. A lot might be settled, but a lot isn't. What do you do with that? We might ask also, does an earlier account based on history become law so that it's subject to stare decisis factors, and you apply those if somebody later on comes forward with some additional sources that may be unsettle even the historical analysis that you used in the past to ground your decision. We also seem, I think, to be developing methodology at the same time that we're deploying methodology. I don't think anyone has really sat down outside of the context of specific cases to ask how, in general, you go about undertaking the relevant historical inquiry, the historically grounded decision making. That's what you think you should do. You surely need some agreement about method before you start applying it to lots of cases. But I don't think that method has really been identified systematically on its own terms in a way as to which there's a sort of agreement as to the soundness of the approach. And then I should say there are also questions that are more normative. The past tends to have been less democratic than the present. So there are indeed objections to various uses of history on the ground that the history itself was flawed in some fundamental ways, flawed in ways inconsistent with our modern commitments. So I said that one of the justifications for public meaning originalism is popular sovereignty. But of course, the people who approved the original Constitution were all white men, some of them slaveholders. Some people object to those people objecting sovereignty in ways that bind us today unless we manage to get through the Article 5 amendment process. Having made that point, I might say that at its time, the Constitution, the US Constitution, was the most democratic creation of government in the history of the world. Nonetheless, from a modern perspective, it was a sort of limited view of democracy. There are objections to all of this, but I do think it's an issue that is worth considering. Similarly, there are objections, I think, to relying upon tradition, particularly reliance upon what the law regulated in the past when large segments of the population were excluded from the lawmaking process. So you can easily imagine this objection. It's been written about by many people in the context of, say, Dobbs and looking back at how states historically regulated or not abortion. So history is doing a lot of work. It's working in different ways, and we're going to see a lot more of this. And as I've suggested, there are some unresolved questions that will take on increasing importance. But I guess the point I would end with is that if you don't like this, right, if you object in some way either to the approach or the reliability or the feasibility or the sort of normative justification of it, then the question for you is, well, what is the alternative, right? You have to have something better. And what is that? And that's really the point at which I will end. And let's then see if there are comments or questions. But thank you so much.
Thank you so much, Professor Mazzone, for the so provoking presentation. We will now begin the Q&A section. I'm sure many of you have questions or comments, but if I may, I do have two questions, and I would like to ask you first. One is related with the U.S. context, and one is related with the context of my country, Taiwan. The first question is about the tensions between the original public meanings and the tradition and the practice after the rectification of the Constitution. For example, when the U.S. Supreme Court, they are looking for whether a right is a fundamental right. They're looking for whether this right is deeply rooted in the country's history and tradition. And so the one mainstream practice is to look at the original public meanings when the Constitution was ratified. But I found out some cases that they also look at the practice after the rectification. For example, like the 100 years of the history after the rectification. And so if the original public meaning is the phase one, and then the after history, the practice is the phase two, I often wonder the role and importance of the phase two. One may say that the phase two is only the supplement to the phase one. That means it can reinforce the argument, the finding we found in the phase one. But if the two somehow conflict with each other, then the phase one wins. But others may say that, actually the phase two, it has independent weight. So it will have a conversation with phase one, and the judges, they will somehow find the middle ground between them. And my second question is related to your the original of the public meaning originalism and the public sovereignty issue you just mentioned. And I will use my country as an example. Unlike the United States, which heavily relied on original public meaning in deciding the meaning of the Constitution, especially the Constitutional Court in Taiwan, especially in recent decades, we almost never use original public meaning in deciding constitutional issues. Especially many people in Taiwan, they believe that using this method is illegitimate because we have a unique history. When we had our constitution in 1947, that constitution actually represents the voice of people living in the mainland China. But because after that we had a civil war, so the government retreated to the island of Taiwan. And so the constitution at the time did not really represent the voice of the people living in Taiwan. So I think that is the reason why that is the case in nowadays. So if I'm a fully textualist, I want to convince the constitutional court in Taiwan and the general public in Taiwan of using like a public original public meaning originalism. How can I convince them? So thank you.
Great, thank you so much. I should say that Mr. Chen is my advisee, so it's always great to talk with him. And he's working on a wonderful dissertation that will soon be done. So let me take your questions in reverse order. So I guess what would sort of be the argument in the context that you described, where there's sort of a strong basis for saying those people, right, who adopted that constitution really did not speak for me today, right? So I think originalists would have kind of two responses or two arguments. So one would be, well, but the text is the same, and the text hasn't been changed, or to the extent it has been changed, and of course you look at the changed text. But the people of today have consented to the text that was adopted in the past because they have not gone about changing it. All right, if they don't consent, then there is an amendment process, or there's a process of adopting a new constitution. But we should assume consent unless they go about changing the document. So it's not only that we are adhering to the wishes of the people who first ratified the Constitution. We are following the wishes of the present population who have not deemed it important or desirable to change that text. So that'd be one argument. And the second argument would be where I ended. What's the alternative, and why is that better suited to sort of the project of democratic self-governance? And you have to explain, right, what that alternative would be, and why that is a better approach. And then on your first question, is a really good question, which is, when you're looking at original public meaning, the theory is you look at the meaning of the text at the time that it is ratified, right? But as you rightly point out, when you look at the cases, the cases are not limited to sources as of the time that the text was actually ratified. This is true of Heller. It's true of a lot of other cases involving original public meaning, in which the court might begin in the 1600s and end in the late 19th century or the early 20th century, and you say, well, what does that have to do with text adopted in 1789 or 1791? Let me say a couple of things very quickly. One is there is a sort of issue that hasn't quite been resolved at the Supreme Court, and it does concern the Second Amendment, and it does concern other provisions of the Bill of Rights. It also concerns, I think, the 14th Amendment, and it's this: you have text that became operative against the states in 1868, right? With the adoption of the 14th Amendment, you're talking about the meaning of due process. You're talking about the incorporation of provisions of the Bill of Rights ratified in 1791 against the state. So there's always a question, if you're figuring out the meaning of, say, the Second Amendment, are you really talking about 1791, or are you talking about 1868? Because that's going to determine what sorts of sources are relevant to discerning contemporaneous understandings. The court in some of the cases has dodged, I think, that issue, has not had to resolve it because, and I think this sort of is something that is going to have to be worked out in the future. It has taken the view, whenever it's confronted this issue, that meaning as of 1791, 1868 was the same, right? So we have to worry about it, right? Whichever point you pick, it's the same. It's the same meaning. So that's one piece of it. But the other piece of it goes to your very legitimate question: why are you looking in general at materials that post date, right? The ratification of text. And I think the justification you would get is one that you alluded to, which is that those later materials confirm earlier meaning, because they demonstrate that even people after the adoption of this provision understood it in a consistent way. The problem, of course, is what happens when those sources don't map onto the meaning as of the time the text was ratified. Again, I think the court has generally dodged that issue because it's been willing to find consistency over time. I think there's a real issue in relying on any of those sources in future cases when they don't map precisely in the way the court thinks that they do. There's not a very good justification from an original public meaning perspective to look at post ratification sources.
Thank you so much, Professor Mazzone. Now we have Simon. You have a question?
Yeah, so there's actually a question in the chat, and I'm going to read that first. This person asked, and he's also in the room, so he can also feel free to speak out to follow up. But the question is, on methodology with focus on the use of history, would you have courts reference history when prior courts have already construed the relevant constitutional provision?
Right. So this It depends a bit on which courts you're talking about. But let's take this the hardest case at the U.S. Supreme Court, and there's some legal issue, some constitutional issue, and that comes up today. But you have a line of prior cases that reached that issue, but did not employ public meaning originalism, right? So what do you do in that context? Well, I think the modern Supreme Court is willing to overturn prior cases on the ground that they were mistaken as a matter of public meaning originalism. And I think if you were to listen to some of the things that Justice Thomas, who's a very strong proponent, of course, of an originalist methodology, his view is that, of course, we should overturn those prior decisions because if they were not based on original public meaning, then they're incorrect, right? The methodology was wrong. Stare decisis should count for nothing in that context. We take out an oath to uphold the Constitution, not to uphold some prior case. And so, if original public meaning points in a different direction, then the answer is simple, right? You overturn the earlier case. Of course, that's a sort of outlier view of stare decisis. Most of the justices are not willing to embrace that view to the same. At least to the same extent. And so I do think that there are going to be contexts in which even if you have justices who are committed to original public meaning or some other historical analysis, who will say, yes, but that's the approach we would have used, but there is respect due to earlier cases and something more than our disagreement, including as to methodology, is required before we're willing to overturn that prior case. But that's the issue that comes up in any sort of stare decisis context. I think the current Supreme Court, if it has the votes, it's quite willing to do this.
Thank you, Professor Mazzone. Simon, you have another question?
No, I mean, just wanted to make sure if there are any questions in the room. And if not, I do have, yeah, but.
Okay, please.
Okay, yeah, so a quick one because I'm running out of time, but so I really enjoyed this session. We had Larry Solomon coming over. We have Dean Chemerinsky to talk about originalism. So I've been thinking about this a lot, and I think the major two camps, right? Textualism, purposivism, and historical, and all of these. And the major critique here is that originalism or historical analysis or all of these, it is actually purpose. I don't know how to pronounce it, but purposed interpretation in disguise, right? It is, they actually have something in their mind, but then history becomes a way to do that. So in your methodology or in what you're advocating, how do we incorporate or how do we acknowledge that sometimes there are something normative inherent in that interpretation, and how do we put that into the equation?
Great. So it seems like there are maybe two questions there. So one is you might be concerned about cheating, right? That somebody really just has an outcome that they prefer, and they're just kind of dressing it up using, they've already reached the outcome. Now let's root around and find the historical sources that support it, right? Some people think that's all that's going on here. But the other sort of idea that is suggested by your question, that first thing is, I think, hard to deal with, right? Because that could be true of any methodology. I think there the challenge is making sure that you have reliable people who can scrutinize the historical sources, who could give a complete historical record, and so on, right? The other sort of related idea in your question, though, is that the person who might be engaged in good faith in the historical analysis might unavoidably be attentive to the purposes of a constitution, right? Might be bringing in, even consciously, right, ideas about what the document is designed to do, right? Doing something other than public meaning originalism or some other historical method. And I suspect that's probably true of most historically oriented analyses. I think the sort of the implication of your question, and I think it's a very good implication, is that what would be most helpful is to be candid about what is going on, right? I think there is some room for candor in this context. I drew this distinction between interpretation and construction, and originalists are fine with that and think that is a necessary aspect of what they're doing. But I do think that, as your question suggests, if there are reasons for attention to purpose, and there might well be, including because, say, the text, public meaning of originalism runs out, the historical sources run out, don't resolve the question, then it may be perfectly legitimate to turn to some other method. But we sure want the person who is engaged in the analysis to tell us, right, what is going on and what the basis for the claim is. I think in all of this, and I think it's true of any method you're using, honesty counts for a great deal. That requires a kind of awareness. I think it also requires a sort of modesty, right? That a lot of this is difficult, and whatever method you adopt might not be determinative, and might have challenges. And I think it's far better to recognize those than not.
Thank you. Unfortunately, we are run out of time. So for those who still have some questions, I saw some questions in the chat box. I will collect your question and send to Professor Mazzone. Okay, is that good? And thank you so much, Professor Mazzone, for this truly insightful talk and discussion. And thank you everyone for joining us.